Welcome to Assemblies of the World with me, Anna Isabel, and my guest today is the founder of the Peacekeepers, Mark Horn. Hello, Mark.
Hi, how are you? Nice to be here again. Nice to see you again.
Well, I'm always excited about the prospect of speaking with you because you have so much knowledge to share with everyone. And it seems that of late, there have been some interesting developments uh, that you've been involved in. So tell us, from the beginning, what it is that you were trying to do and how you've got there and where you are right now.
Yeah, basically, uh, there's over 4,500 pieces of primary legislation, over 25,000 pieces of secondary legislation. Nobody can read that in a lifetime, let alone comprehend any of that. And in addition, there are hundreds of thousands of judicial decisions, which make up what's called case law. So going back to the fundamentals is what we need to do, because nobody can, process that full body of information and apply that. However, they all of those things come out of and must comply with fundamental principles. So what in the US Constitution or Declaration of Independence, it talks about self-evident truths. So that's always the starting point, where we need to go back to. You cannot get more fundamental than that. So to explain this, and once people understand it, you'll understand the total foundation of your relationship with anybody else, including those governing, including your relationship with the courts, and including your relationship with the legislative bodies of state. So it's all based on self-evident truths, and basically that means 99.99999% of the people can reach the same conclusion because we are all the same. We connected universally through our conscience. Our conscience dictates what's right and wrong. And the creator, whatever that is to whoever, gifted us a mind. That we then apply with logic and reason to the tools the creator gave us to observe: our eyes, our ears, our fingers, touch, taste, hearing, feeling. So then with those observations, we've applied rationality, and therefore we create this common reality because the vast majority of the people will reach the same conclusion. So this is basically the observational tools are our tools which collect evidence. And then we apply the logic and reason, and that's exactly how the legal system or lawful system, whatever, they're both the same. They're both designed to incorporate that, which is natural justice. So we have natural justice in the common law, and in the legislative system, it confirms natural justice. So the self-evident truths are that if I can't tell you what to do, and you can't tell me what to do, then nobody can tell anybody else what to do. The only way that authoritatively that can change that relationship is an agreement, i.e. by consent. My rights end where your rights start, because neither of us can prove the right to impose our will on the other. And therefore, all interaction must be by consent. There is no other possible way of it being done in law other than by a trust. And it's the creator's trust those governing are imposing their will upon. So,
Okay, before you go any further, explain trust then to us because there's quite a lot of um, around trusts at the moment.
Right. For a trust to exist, there must be somebody granting something and putting that into trust. And that's the noun or the trust property. So you have trust as in a noun. And then what you have is that person that's granted the trust is trusting the verb, the trustee, the person responsible for administering the trust, to do so for the benefits of the beneficiary. So you do not need to know you're in a trust. So for an example of that is a will, last will and testament, where somebody grants the inheritance, what they're leaving in the material realm, to a person who's going to administer the trust for the benefit of somebody else. Now, neither the trustee nor the beneficiary need to have knowledge of this. However, once they're with the knowledge that they're a beneficiary, they then can hold the trustee to account to uphold the law of the trust, which was created by the grantor. So creation, creator, God, Allah, whatever you want to call or your belief system is, everybody would agree this common reality somehow has been created. We can't explain it. So the creator of everything is the grantor of the trust of this common reality. And it's actually expressed in the Bible, and therefore, as the monarch, like we saw last year, King Charles, he swore on the Bible, he took his oath under the Bible. That's an admission of a higher law than what the monarch creates. And in Genesis 1:26 to 28, the trust actually is expressed. The Creator made us in their image. And then it continues, created all that is for the benefit of everybody. It
Okay.
doesn't. Hmm? Go
Okay.
ahead.
That's really important because irrespective of what anybody's religious or unreligious beliefs are, this is the foundation of our law. And if the king is still swearing on the Bible, that makes the Bible a legal document.
Correct. And it's an admission of a higher law, a law greater than man.
Okay, well, that's quite important, I think, for what follows then, isn't it?
Yeah, yeah. So, so because it says in there that it's for the benefit of man, everybody. It doesn't say only for the benefit of the rich or this bloodline or that bloodline. And it continues that it grants dominion of all that is to man. So if we first look at the beneficiary, we therefore are all entitled, because nobody can prove from the creator the right to anything more than anybody else of the creator's creations, or that they have the right, i.e. more authority than anybody else, to a greater share or to impose their will. And logically and rationally, that's the only possibility. Without proof of authority from the creator or creation, whatever it is, to whoever, we are all therefore bound by your rights end where my rights start, and we are all entitled to an equal share of global resources. And until somebody can evidence authority more than anybody else, logic and reason dictates we are all equal under the law and nobody's above the law.
So, in terms of foreign policy, for instance,
Yeah.
our relationship, so that's very clear in the law of this land, the structure of the law in this land.
This is truth. Until somebody can evidence it, it applies on the whole planet to every single person on the planet.
But I was actually wanting to clarify then,
Yeah.
is what happens when we are signing treaties with the UN, so the WHO treaty.
Okay, we'll come to this in a minute. Okay, if we first look at the fundamental truths and how those can be rebutted or changed, everything that comes out of it must abide by it, because this is the highest law. If I can't prove authority to do anything, impose my will, i.e., I do not have authority to cause you harm knowingly, because we've never lived before. We all make honest mistakes. So that they creates the fundamentals of all are equal under the law. Nobody's above the law. And with the trust, if somebody is imposing on the creator's trust, because we are all entitled to equal share of the global resources as beneficiaries, and they intervene with that right, they are trespassing on the creator's trust, and therefore they are accountable to the people again. So whoever chooses to govern, it doesn't matter if it's a dictator, a tribal leader, if it's a king, if it's a democracy, it's all irrelevant. Because without authority from the creator, they have zero authority to do what they're doing. They have no authority more than you or me, and they are trespassing on the creator's trust. And in law, they are accountable to the beneficiaries and liable for harm caused. So with that structure, like you were just saying there, who the hell is Parliament? They cannot evidence any right to impose even their own will on us, unless by agreement we consent. So what they do in regards to who or WEF or any of this, it's none of your business. You are not a party to that relationship. And until they can prove the right to put their will on you, there is, in law, no way to do that. As trustees of interfering with the creator's trust, that does not give them the right. In fact, it does exactly the opposite. It makes them accountable and liable for harm they caused by breaching the self-evident truths. Does that make sense?
It makes complete sense. So tell us then what you've been doing.
Yeah. So on this basis, we've got that they basically you can call natural law, divine law, God's law, whatever you want to call it. That's the self-evident truths. So the three self-evident truths are we're all equal under the law, nobody's above the law, and we're all entitled to an equal share of global resources. However, dominion means not only are we beneficiaries, we are beneficiaries in our lifetime, but dominion brings with it a fiduciary duty to future generations. Therefore, we must apply the best available knowledge so as not to cause harm to future generations. And therefore, we are custodians of the planet, each of us, whilst we are here for the benefit of future generations. We have no right to knowingly cause the planet harm. So that there sets out the hierarchy of law. Everything else that anybody that trespasses upon the creator's trust must comply with those conditions. So what we've got is the application of that means that we can establish a hierarchy, and this is recognized in law. So basically, it was resolved in 1610 in the case of proclamations. So this is basically the monarch, all of his advisors, the judiciary, those governing, resolved and agreed, and therefore defined that the law of England is from three sources. The first source is customary law. That there's unwritten law. So we are here doing this interaction through customary law. We've not written anything down. We've not specified terms and conditions. And customarily, when we have a discussion like this, there's certain customary behavior which both of us will abide by. And if either of us don't like what the other one's doing, we'll just call it to an end. Because if we don't like what the other's doing, that's causing harm. And we have no right to impose our will on the other. So one of the first aspect of the law of England is customary law, and most of our lives is controlled by customary law. We go out, we talk to people, we go shopping, this, that, and the other. There's not always written law for what we do. The second part is the common law. The common law is where we have private, everything we do is in private. And when we cannot resolve a dispute, and most disputes result from misunderstandings, that can be bad communications, it can be expectations, it could be presumptions, it could be assumptions. But when somebody feels they're being harmed by that, then a dispute will arise. If we cannot settle that dispute in private, because nobody can prove the right to knowingly cause another harm, that then means automatically all human interactions about peace. Because if somebody's being harmed, then you're breaching the peace. So that then requires, to keep the peace, public dispute resolution. And that there needs to comply with the fundamental law. So that there then results in what's called a precedent being the way that the decision to resolve the dispute has been made. So therefore, it's the principle or rule of law that is the precedent. That precedent then you can apply to multiple things. So for instance, it's simply a tool. So if I've got a spanner or a screwdriver, it doesn't mean that I can only put in stainless steel screws or stainless steel bolts. It doesn't mean I can only put in brass screws or brass bolts. The tool I can use for brass or steel or any material, including plastic or anything. So it's about finding the appropriate tool, which must be rationally derived to apply to a problem. That is what a precedent is. And that there is the common law. And through logic and reason, we can determine what is fair and just. So that there is written law, or one form of written law. So it's not the judges making law, because they are bound also by all are equal under the law, nobody is above the law. So when people talk about judges creating law, that is a total misunderstanding, because the judge like you and me is bound by the higher law. So that's one type of written law. And the second type of written law that it was resolved was statutory law, i.e. statutes or legislation of those governing. However, that there's constrained in its jurisdiction, i.e. who does that apply to? So statute law is also bound by the higher law, and therefore, as nobody can impose their will upon another, in the introductory text of statute law, they tell you, be it enacted by and with the advice and consent of the Lord Spiritual, Lord Temporal, and the Commons, by authority of the same, i.e. the people that are involved in statute law have created a common law contract, which they're perfectly entitled to. And it's a contract between the contracting parties. You and I are not a party to any act of parliament. And so those are the three types of law: customary law, common law, and statute law. And each of those is bound by the rule of law, which is all are equal under the law, nobody is above the law.
Okay, question for you.
Yeah. Whoops, you're frozen.
The church from the state, so that the monarch is no longer head of the Church of England.
Fantastic.
And
it's about time the church got out of this nonsense. The
so
church.
does that have implication for the structure that you've just outlined?
Well, in theory, all that happens is because the church has been given special privileges. So if we go back to the fundamentals, if all are equal under the law and nobody's above the law, by impossibility, the church cannot have special privileges because it's no different from you or me. They rely on, their evidence is the Bible. However, in the Bible, it doesn't say that the church is God's representative on earth. Therefore, it is no authority. It's merely a belief, and that they are God's representative on earth. And that there really stems from it's political. It's a way of controlling people. And so it's merely a control system whereby somebody is trying to impose their will on somebody else through their interpretation of somebody which may or may not have written something.
So my concern was that if we were separating the church from the state,
yeah,
whether it mean that the oath of the monarch would no longer be on the Bible, and we would lose that sense of the trust created by as a result of having the creator.
Basically, the rules of equity resolve this question. It is your intent, and the intent is legislatively affirmed to be binding under the Oath Act 1978. If I intend to gift you something or enter a business relationship or any other relationship, then I am bound by it. So my word is my bond, honor. Okay, the equitable principles are basically honor, good faith, and clean hands. Honor means my word is my bond. I walk my talk. I do what I say. And that can be either spoken or written. That's the intent. Good faith means when I enter any relationship, I do not put my self-interest above anybody else's, which is one of the self-evident truths. Unless I can show the right to impose my will, I have no right to put my interest above yours. And the last one is clean hands. And that means I do everything openly, honestly, and transparently. And that there is to minimize the risk of misunderstandings and hence for grievances arising out of misunderstandings.
Well, something's badly wrong, hasn't it?
Yeah. And so basically what we've got is the church, okay, is without evidence making a claim of the right to offer the right to govern the dominions to the monarch. That's the relationship. Nobody's ever challenged the lawful right of the church. So therefore, by separating the church and removing it from it, it does not remove the rules of equity, because that's part of common law. Okay. And is supreme over common law, where the common law is not fair and just. But also think about it, by having the Church of England as supremo, okay, you are actually directly discriminating against other people's belief systems. And that is unlawful, because that is not treating all equal under the law. and it's putting somebody above the law. So therefore, it absolutely should be removed from governance, and simply it would just remove the third promise, which is correct, fair and just, not to give the Church of England preferential treatment over anybody else.
Okay, good. So at least we know that that relationship based on God's trust
Yeah.
it remains intact
Yeah,
if the church is separated. So
absolutely.
coming back then to these principles of law.
Yeah.
So what have you been
So applying these fundamental principles, okay, because it was also resolved in 1610 that the king hath no prerogative but that which the law of the land allows them. To understand that, we need to understand what is the law of the land, and that there's admitted in the confirmation of the Charters 1297 to be the common law, as was at the time expressed in the Great Charter. So people can argue about Magna Carta 1215, 1297. It really is irrelevant. But it says the common law. Stare decisis was introduced with the Normans when they invaded the UK, and stare decisis simply means once a judgment has been made, that applies equally under the self-evident truths to everybody, including the monarch, those governing, the judiciary, and everybody. And the real substance is that the right to trial by jury is you cannot be a judge in your own cause. Therefore, if the king is supplying the venue for dispute resolution, he cannot supply the people that are going to decide. So the trial by jury is to put the public, because we're all equal under the law, to get a random selection of the public to determine whether harm was caused or not. As an independent jury, representative of the public, because we're all equal under the law and nobody's above the law. So that's the substance really from it. So just back then to the application of it, we know therefore that law of the land is common law. We understand that common law is the reasoned judgment, i.e. not the judge making up law, but following principles and rules, just like the rest of us have to make written law. And it was resolved that the common law, the law of the land, gives the right to govern. The king has no prerogative but that which the law of the land allows him. And therefore, as statute law, remember the third source of law that was resolved to exist must be and can only be subject to the common law. It cannot change the common law. It cannot supersede the common law. With or without Parliament, the king on his own, it's totally irrelevant. So that there's the set out and the basis of the constitutional principle of the rule of law. Whoever governs is subject to the rule of law. And the primary rules of law, we all equal under the law, nobody's above the law. So that there's the foundation of what we're doing. So statute law must comply with common law. And what's happening is that people have a belief that statute law is supreme over common law. However, that belief is neither rational nor can that be evidenced. But the judiciary, the judges over the last 350 years have taken it upon themselves to create that belief by upholding and choosing to put statute law above the common law. Now, going back to the three types of law in England that it was resolved, okay, the law of England is custom, common law, and statute law. The judges have put statute law above common law. It was only resolved there were three types of law, and that statute law derives its authority from the common law. But the judges have inverted this over the last 350 years by enforcing this, which has created a public belief that they must comply with legislation. That's the problem. And the judicial oath is, guess what? It's to the law. So therefore, they actually are bound to customs, common law, and statutory law. So by them only upholding statutory law, i.e. ignoring the other two sources of law which bind them, they are breaching their duty to the common law. And because statute law derives its authority from the common law, that means they need to test the legality of acts of parliament. That is their job. They are judicially bound to determine that, but they are breaching that duty, and therefore their decisions that they make, where they do not determine the lawfulness of legislation, that there's a breach of duty, and we now are starting to bring claims against judicial officers who are not doing their job.
Can I just take you back then? Because there's been a lot of talk of the fact that the oath that is sworn by judges is to the king and not the law. Is that
No, the oath is very clear. There are two parts to it. One is allegiance to the king, and the second is independent of the king to uphold the king's second promise. Okay, i.e. to law, the first promise of the king is to govern the people according to the people's respective laws and customs, our laws, using statutes in parliament agreed upon. So that they reaffirms the purpose and function of statutes, because the royal prerogative, His Majesty's government, that implements and upholds the peace, is bound and derives that authority from the common law. An act of parliament is a common law contract between the king and parliament, the legislative body, that they will both comply with that. And so when the king is in breach of his oath, i.e. to treat us all equally under the law and nobody above the law, which is what all of our everything derives and must comply with that fundamental truth. Parliament in Article 13 and under the powers granted and agreed between the monarch and Parliament in Articles 1 and 2, literally is no different. An act of parliament is merely when the king is not doing his job to govern us according to our laws and customs, parliament gives them a warning notice, an act of parliament, and say, do your job properly.
okay? So that is completely different to the reality that we are experiencing and have been experiencing, I think, for a few seconds.
Yeah.
So now the question is, so if the judge is meant to be testing legislation or statute law,
yeah,
against the reality of what should be happening,
correct,
what is the job of the lords? Because should they not be doing the same thing?
Yeah, well, okay, because they have a belief that they are above the law and can do what they want, when they want, to whom they want, okay, they just do what they're doing. It's a bully. If nobody tells you you're doing wrong, you will carry on doing wrong. The way they justify this is by saying, oh, you voted for us. Democracy. So if I vote to create a binding relationship, you then are bound only by what you told me. Because if you're trying to do things which you haven't told me, my vote cannot be deemed consent. So if you come with your manifest and say we're going to drop taxes by 5% or raise taxes by 5%, then I could be deemed to have that there's basically a contractual relationship. I have consented. However, the question is, what about the people that either didn't vote or voted for somebody else? So there's no way known in law that anybody can impose their will on another. If they use mental coercion, it's even the common law is legislatively affirmed in the Fraud Act 2006. You can't mess with people's minds for your own benefit or the benefit of somebody else. Physical coercion is crimes against the people. Public order acts, there's numerous of them. Using physical coercion is, again, partially codified. It's common law that nobody can impose their will. So physical coercion is because nobody can prove the right to impose their will on another. That's what the common law says. I can't physically harm you without your consent. And even that there is an act of parliament or a series of acts of parliament.
That's what the common law says.
And the act of parliament is basically saying to the king, okay, this is happening, and therefore we've made the Public Order Act. Make sure that it doesn't happen again. And then the third one is stealing people's property. That there's the Theft Act, and it's associated with the Fraud Act. Again, it's a codification, a legislative codification of the common law. It's wrong in common law because nobody has the right to steal other people's stuff. Nobody has the right to physically force somebody, blackmail, threaten, intimidation. Nobody has the right to mentally coerce somebody. So that there's a very good example of how we, the people, create the common law using logic and reason in the independent judiciary. And when the king's not doing his job properly, governing us to our respective laws and customs, Parliament says, hey, mate, here, you're not doing your job. Here's the Theft Act 68 or whichever it is. Do your job properly. Okay. And then the judges are, their oath is to law. The monarch's first promise is to deliver law and justice in mercy in all your judgments, whatever. That there is according to law. And therefore, the judge is taking upon, by their free will, the duty to uphold not only the king's promise, second promise, but also the judge is taking it upon themselves to uphold the law, which is the people's law, the common law and customs that we create between ourselves in private as equals under the law. So that's how the whole thing's connected together and what the relationships are. And it's everybody, judges, MPs, Prime Minister, King, matters not. They are all and have agreed to bind themselves to the law. And the law is we're all equal under the law. Nobody's above the law. Therefore, nobody can tell anybody what to do.
So this is where you come in, and what you're doing is very exciting because you're working to remind everybody that they are bound by the law. So tell us about
that's what it is. Yeah. So basically, people are, personally touched. Most people are personally touched by council tax. And so there's a self-interest. And that's why it's, quite popular. Many people challenge council tax in many different ways. So basically, in the council tax, that derives legislative authority from the Local Government Finance Act 1992, where in section 1 a presumption is made, and in section 6 more presumptions are made. So the judges, I absolutely have no issues with having the statutory duty on our behalf to check that those people, the government, are doing and their job in accordance with what Parliament has said. So basically, they do a tick boxing exercise when you go to a council tax hearing. Has the budget been set? Tick. Has the demand notice been sent out? Tick. Has the it not been paid within 7 days, and did you send a reminder? Tick. Has it not been paid? Did you send a final reminder? Tick. Have you issued a summons? Tick. Has it still not been paid? Tick. So therefore, they fulfilled their statutory duty to check and balance that the council is doing its job properly, according to what they've been told. So that there's a statutory law. However, those details are in secondary legislation, the Council Tax Administration and Enforcement Regulations 1992. And in its introductory text, it will tell you what gives that document authority, the Local Government Finance Act 1992. So we go then to the Local Government Finance Act 92, and that says in its introductory text, be it enacted by the monarch at the time of Queen Elizabeth, by and with the advice and consent of the Lords Spiritual, Lords Temporal, and the Commons, by authority of the same. Common law contract between the two of them. Parliament is saying to the government, okay, you must do this is what you need to do. Go and collect tax from the people living on the land. So what we're saying is, great, I fully understand your claim, your belief system. What you believe gives you a right to steal my stuff is what it boils down to. However, that is your statutory duty, Mr. Justice. And remember, even lay magistrates have the same oath as the highest Supreme Court justice. They are all equal under the law and hold equal power and equal duty to us. So what I'm saying is, in 1584, there was a case called Hayden's case, which precursed what I was saying about happened in 1610. And that there is called the mischief rule. And that there defines when Parliament can interfere with the people's respective laws and customs. It's very restrictive what Parliament can do. So basically, the rule says if there is no remedy for a mischief, then Parliament can create a rule, but it's still bound by the rules of law. This here is to allow another mechanism, and a mechanism which is a good protective mechanism, to allow society, people together, to more rapidly respond to the unknown. So if we look at the recent stuff that happened around 2019, 2020, and from then, potentially there was an unknown risk. We didn't know what it was, and we didn't know how severe it was. However, some people believed it really could dramatically harm people. Therefore, under the precautionary principle, if we don't just walk into a dark room at full speed, we look, we get a light, we take precautions so that we can safely navigate through the dark. So with the precautionary principle, based upon the belief system at the time by, various people, it's not about whether it's true or not, it's about their belief, okay? Everything's about belief, okay? who can impose their belief on somebody else for their self-advantage. That's all it is. Okay, so they then therefore enacted the Coronavirus Act 2020, which itself relied upon there being a protagonist, and that protagonist can jump from one person to another causing harm. However, in truth, what is the job of the judges? If I ask for the evidence that the protagonist exists and that it can cause, jump from person to person and cause harm, he who claims must prove their claim. Therefore, those governing must prove the protagonist exists and can jump from person to person and cause harm. If they cannot, based upon the evidence, the self-evident truth of what the judge has seen, heard, touched, and that, they must rationally make a determination of the evidence. Therefore, if you question and want them to prove their claim, and they fail to prove the claim, that means no enforcement of the Coronavirus Act 2020 should take place until that presumption is met when somebody asks for it to be proven. Therefore, as soon as that proof can't be given, that then stops any possible enforcement coming out of it. So the same principle applies to every act of parliament, because acts of parliament require royal prerogative to be enacted and that changes a bill into statute law, because that they binds then parliament and the government to do, where the government is agreed, I will do what parliament tells me. When and how, I will continue with everything I do, and if they see I'm doing something wrong and causing harm, they will give me an act of parliament to mend my ways. Okay, so the presumption is that they have a right, parliament has a right to tax people living on the land. So the question is simple: show us the authority. Where have you gained the authority from the Creator? Because we all have an equal right to live on the land. So show me where you have authority to demand money from me, because spoiled children demand. They even tell you they demand, but I want to see the authority, and I require you to prove that before a judge or a magistrate, a lay judge. Okay. And if you can pass that test, that you have a right to charge for the land that we live on, then I need you to prove the authority that I am liable to pay that. Obviously, neither of which exists. So that there is actually a duty of the judge. We all have a right to the land, and the mischief that's being created is actually by Parliament. And where is their authority? It is not in the common law that they have authority. So where, basically, firstly, as Parliament got the authority to be the tyrannical king, because the whole idea of the Bill of Rights was to remove tyrannical kings. Okay, so show me where God said, you are God's representative on earth and can tell me what to do and steal my stuff. So it's the people not understanding the basic relationships that I've set out. Okay, all I'm saying to the judges, you are duty bound under your oath, which was clarified in 1610 to the common law, and you must determine this relationship, because without this relationship, there's no joinder. they have no lawful claim, therefore you must dismiss the complaint for council tax. Does that make sense?
It does make sense. Just a question though, because coming back to the principle of custom,
Yeah.
kings have been taxing people forever. So could it be claimed
I've
that this
only
is
been around since 1964. I don't give a hoot. I was no part of what happened forever. It's got nothing to do with me.
brilliant? Okay. So this is your statement, and how are you doing with that?
Right. So basically, those that don't know, Liverpool Council withdrew a £15 claim. I've got flats, and when tenants moved out for 1 or 2 days, Liverpool Council come after me for council tax. So 2 years ago, they actually withdrew their claim because I got the magistrates to order that they answer my notices, that they, give me a reasoned explanation. If I'm wrong, I'm wrong. Explain to me why, and I can reevaluate the evidence. So instead of giving a reasoned explanation, Liverpool Council decided to withdraw the claim and for £15.64 or whatever it was. Now, people don't understand the significance of that. And in the alternative truther movement, basically they're saying, oh, it's only 15 quid, of course, this is just rubbish. It shouldn't even be in court. However, whoever loses the case pays the winner's bills. Okay. So whether it's £1, 1 penny, or £10, £100, or £1,000, if you're right in law, the other side pays your costs. Therefore, it was not an economic decision to withdraw. But as is usual, people don't look at the evidence. And so a lot of the alternative truthers were saying, nobody's going to take you to court for 10 or 15 quid. Okay. And do not understand the underlying principles of law. Anyway, this time the council came after me for £75, went to court, but because I've got through the peacekeeper course and the court auditor course, the job of the magistrates, and we've become very clear now that that duty includes common law duty, and we've literally got the list, a tick sheet now. We've got a tick sheet of what they should be doing. Just like they've got their tick sheet, has the budget been set and all of this, okay? We've got a tick sheet of what the job of the magistrates is. So first thing is the complainant sets out their complaint and their evidence. Tick. Then we have the right to cross-examine that witness. Cross. Didn't do it. Then I have the right to present my evidence. Cross. They wouldn't allow me to do it. But in the conversation, they admitted that the council had not given the court the costs either. And therefore, cross, the court could not have reached the decision that their costs were rational. Amongst many other, lots of other things they, did wrong. Including by refusing my submissions. They did not even take my evidence. And they told the legal advisor to give it back to me. So plus I had my witnesses in the public gallery. And so I put in an application to void the order. Okay. Now, a void order is simply an order made without authority. They had no authority to make that order because they did not do their job properly. Therefore, it's as if the order does not exist. However, it's still enforceable until the enforcement agents, i.e. the creators of that order, the courts, nullify it, set it aside, void it, whatever word you want to use for it. Basically, that order creates the law between me and the council and gives the council the right to enforce it. If that order is wrong or without authority, that order is as if it doesn't exist. However, it's still enforceable until the court tears it up. Okay, so so I put in an offer to the court to correct the mistakes of its judicial and other authorities. I offered to them, fix your mistake. Kate, I'm on the with Anna. Kate's just come home. So I offered them to correct their mistakes. They are causing me harm and they need to fix the problem. Now, each of us individually has the obligation, if we're causing somebody harm, to stop. So I offered in the court for the judges to correct their mistake, and they thought, forget it, no. And so I wrote to the legal fiction, i.e. the principal agency of who the judges work for, the magistrates court. And I said, hey, mate, your people have caused me harm. They've not done their job properly, and you need to fix this problem. Within 5 minutes of the hearing to void the order, the deputy and the district judge agreed with me. In fact, he even verified that the legal advisor had confirmed the mistakes that they made, that they acted without authority. So as a result of that, basically, I've got the council are still wanting to come after me for the 75 quid. And there's a hearing set on the 12th of August here in Liverpool, where in addition, the judge gave directions where I had to summarize, basically narrow the issues, which is prove that Parliament's God, and that you God's agent, and that you can steal my stuff. I had 4 weeks to provide that to the council. They had 4 weeks to come back to me to rebut my stuff. And this is where it'll start to get a bit more technical. However, basically, what the foundation of what I've spoken about earlier, that there is the authorities I rely upon. The case of Proclamation 1610, loads of case law. And in order for them to get around that, they need to provide higher authorities. So if they cannot provide a higher authority than what I have, guess what? The judge has no choice but to follow the highest authority in the evidence before him. So if they cannot rebut my authorities saying where or when and what evidence have you got that Parliament is God, the judge is going to have no choice but to dismiss the case. So we've really refined what we've learned over the last 2 years. So not only is it my order that we've got in, we've got a second one as well now, where we've got a hearing on the 27th of June. On the 20th, so next week, we've got another one where we're doing the same thing in north of Manchester. There's somebody in Buckinghamshire, and we're doing, basically enough people now are doing this around the country so that we are getting the results. So, but this is now reaching the point where it's forcing, we're telling the judge, you have a duty to me under your oath, and if you don't do your duty, I'm going to sue you. So what I've done in Liverpool, again, I like to lead by example, and so that I can work out what is the path that works. I'm actually suing the 3 magistrates and the legal advisor, and I should have a reply before the end of the month. And the grounds are, you did not do your job properly, and therefore you've caused me harm, and therefore I am suing you. And my evidence is simple. The district judge has already confirmed that they breached their duty to me. So, and this is what we will be starting. So I'm maneuvering through it. Once we've got this route through it, and the main issue is going to be whether the government legal department thinks it can intervene in a private claim between me and that magistrate, or each of the three magistrates and me and that legal advisor, because they weren't doing their job. That means the government, the taxpayer, has no right to waste taxpayers' money protecting its people when they're not doing the job for the benefit of the government. So we're driving a wedge now between them and hitting them in the pocket, because we need to change the risk-reward relationship. If you want to be a lay magistrate, okay, it's not all about tea parties and being with the mayor and invitations to dinners. You have a duty to us, the people, to uphold our laws and customs in accordance with your promise. And then from that, basically, we have the prima facie evidence to bring criminal charges against them, so that we really start to lock up these bad actors. That changes the risk-reward relationship, and therefore they will change their behavior. And we're progressing also with charging orders, and we've got 3 void orders. And basically, this is how we maneuver between the common law, which is supreme over legislation or statute law. In statute law, what they say is, if you've got this problem like Mark's described to you, go to judicial review and they'll quash the order. What I'm saying is, listen, I'm not interested in that, because that does not get me remedy. It does not get the people remedy. And therefore, I don't need to use your avenue. Thank you very much. I'm using the common law route. My rights as an equal under the law, and everybody else's duty as an equal under the law. So it's about moving out of legislation into the common law and getting your claim through in the common law by holding the next judge to account to their oath, their common law duty. So it's about changing the risk-reward relationship, so that basically between now and September, end of August or middle of August, a lot of this should be evidenced as to how it works and how to do it. But the wheels are in motion on it.
Well, we wait with bated breath here, because it's crucial, isn't it?
This is the problem, the judiciary not doing their job. It's not Parliament. It's not the World Health Organization. All of that's irrelevant. It's the judge who is not doing their job. And us, the people, who do not actually know what their job is. So quite simple. If I know what your job is, I don't have to prove my right. All I have to do is prove your job and where you're not doing your job. Therefore, you are not acting in the capacity of a government agent. You're acting in your personal capacity, and therefore we will sue you in your personal capacity and send the bailiffs around to these magistrates. Send them around to their houses.
So in situations where government acts to, let's say, I'm just waiting.
It should act in the public interest.
Yes. So,
Okay.
but situations where they proclaim to act in public interest, but actually their choice, as you were talking about, this precautionary measure that was taken, and it's supposed to be in public interest. However, there is demonstrable damage that has been physically done to people. Does that mean then that ministers themselves can be personally held liable for the personal damages that has been
Correct.
brought on individuals.
Yeah. Basically, they are putting in a legislative fence, okay? But because that fence stands on common law, where that's in breach of the common law, the fence gets knocked over and you get them then in person, if that's a good enough analogy.
Well, that's very encouraging because given that we stand to replace one somewhat tyrannical government with another one
It's all the
with
same. People,
more tyrannical,
yeah.
it's good to know that we can take action and actually do something to restore the order of things to where they should be.
And there's, okay, I've been pushing this now for about 2 years, and there's about a dozen people we are directly challenging in 3 or 4 areas around the country on the same principles, and they are reacting. They are panicking. Well, maybe there are a few individuals that are panicking at the moment, but as we start to people get to understand it, and we literally have templates that it's repeatable. It's a module, okay? And if you apply those principles, it doesn't matter if it's a computer-generated template, okay, which is what they accuse us of. It's about the truth and substance contained therein, and then about internalizing that to put your energy into it, because when you go out, and even if you email it, your energy will be received by whoever's reading it. So it's not that we can change it for you. We are not heroes. Only each person can do that. But it does not take a great number of people to take the time to educate themselves, to take the lead in this, because all that happens is it's human nature. We do, what's in our best interest. And once we see that the judiciary is returning to doing its job properly and being independent from and not doing what government tells it, but being a true balance between the people and those governing, once they see it's in their benefit, and we're starting to sue enforcement agents as well, basically, until they stop their nonsense, we're going to just sue them. And send the bailiffs around their place to collect their money, so that their risk-reward relationship changes. And it's not going to be worth their while to go and become an enforcement agent. If you want to become a judge, then you're going to have to do your job.
So I can think of no better reason to join up and do the Peacekeepers course, so that there are thousands of us doing this. So Mark, what is the website for the Peacekeepers, and a reminder to everyone that this is free?
Yeah, it's peacekeepers, one word, .org.uk, and the courses are there. You just need to sign up. Then because time's limited, my time's limited, we've got a Telegram group where people can discuss about the course and application of it. And then there's a separate Telegram group for the challenging of the council tax. But the idea of the council tax challenge is, we're not saying we're not paying. What we're saying is, prove that I must pay, and once you've done that, I'll pay. So it's not to get out of paying council tax, but it's to address the fundamental relationship between those governing and the governed. And so you'll find a lot of help and support on there. We've got about a dozen people now, like I say, who are actively challenging in courts and helping other people in courts. Taken us 2 years to get there. In another 2 years, that's going to be over 100 people. And by 2028, there'll be over 1,000 people. Don't even need 1,000 people to change this.
Okay, well, that is the incentive to everyone to
Yeah.
actually beat the prediction.
Yeah. Get on board so that we do this by 2024, 26.
Mark, thank you so much for your time today.
You're welcome. And thank you for your time. And thank you for watching this, all of you out there. Let's be the change we want to see. Let's get
Ab-
off backsides and do it.
Absolutely. So join up, do the Peacekeepers course. And of course, if you have not already done so, do join us. Community assemblies of the British Isles, assemblies of the world. Let's get together
And get this finished.
and be the change we do want to see. Thank you.
I know.
Until next time, goodbye.
Okay.